Okay, I've got my document open here. So, just out of curiosity, are you the only person on this call?
No, my partner is here with me as well.
Okay. Okay, I see. That's how you. I guess that's okay. I mean, I wasn't expecting to be talking to. Is that how you usually have discussions? I guess.
Actually, this is her training week. Her name is Amy.
Oh, okay. Okay.
She's just learning how to handle the calls this week. Normally, this would be a one-on-one call.
Right. Right. So next week it would be just one-on-one.
Yeah, if you're uncomfortable, I can pick up the phone.
Okay. I guess I would. I guess I'd kind of rather just be one-on-one.
Okay. Okay. Just a moment.
Okay.
Hi, Greg.
Hi.
Hi. Is that better?
Yes. Yes, that's better. So she's still there. It's just on. It's just not on speaker, I guess.
That's correct.
Okay. Okay. So anyway, so this is a pretty complicated situation, and so and the thing is, I'm not exactly sure whether these people have done things which can be complained about. Like, in other words, there are things that I take exception to, but I'm not sure whether these are things that can be complained about. And I'm also not sure how to prove wrongdoing, so that's why this is a little bit complicated. So,
that might complicate it. Okay, so we'll just take me through it. What happened?
okay, so and the first question is there a limitation date for complaints?
No, you can go back as far as you want.
Okay, so that's good. Okay, so the first one is, and I might as well tell you their names, right? So I can.
Sure. Yeah.
Okay, so the first one is Mark Grotsky, and he's from Grotsky and Hostin in Edmonton.
Okay.
And he's not a lawyer that I've hired, but he's a lawyer who was involved, and I believe he's still involved with people who I've filed a lawsuit against.
Okay, involved as in they are his clients?
Well, it's a bit complicated and uncertain exactly what his involvement is currently because at the time of the events of my lawsuit, he was not exactly representing them, but he I believe he's a family friend of these two defendants in my lawsuit, and so the events that he's involved in were from May of 2013. So, and he swore an affidavit, and he witnessed an affidavit of one of the defendants in a previous situation. So, to kind of describe what's going on is, so I filed a lawsuit against multiple defendants, and it includes these two specific defendants who I know have had involvement with Grotsky in May of 2013. So, so my first question is, like, when I file a statement of claim, and I filed this statement of claim on April 22nd of 2015, and then I served it. So I've been serving the defendants. Like, there's a bunch of defendants. There's defendants from the police. There's other defendants, and then there's these two defendants, and their names are Paul Keefe and Raylene Keefe, and they're a father and daughter. So, so my first question is, like, when I file a statement of claim, obviously when I go down to the courthouse, it's filed as a hard copy, but is it scanned into a digital copy that makes it searchable by names or by keywords?
I don't know about searching, but generally speaking, the parties' names are added to a computer database.
Right, so it's actually searchable by name, and the reason why, so it's in a database that's like searchable by defendants, I guess. Okay.
Yeah, it should be searchable somehow. I'm not 100% sure on who has access or at what point along in the process that they become publicly accessible.
Okay.
I don't work at the courthouse, so I honestly don't know.
Right. But
I know that most of it becomes completely publicly accessible once there has been a decision rendered.
right. So,
until that time, I'm not sure.
okay, so that makes sense. But would a lawyer be able to search that database for names and keyboard, like names at any point once it's been entered?
Honestly, I do not know.
Okay, that's okay. So, and the reason, like, so I was, wondering, like, in general, would a lawyer have access to search for a statement of claim if he knew what names to look for? And I guess you're not sure about that, eh?
No. If an action has been filed against someone, it should be in a database and it should be findable. Particularly if you are going to file a new one. You know what? I don't think the lawyer would be able to search it directly. I think they would have to either go to the courthouse or call the courthouse and ask them to run a search for particular names.
Okay. I see. So, the specific reason why I'm asking that question is because, so like I say, I filed this lawsuit against multiple defendants on April 22nd of 2015, including those Keith defendants who are known to Mark Grotsky. And so, like, I've spoken with a lady at the law at Link at the law courts who says that he's a. Pardon me?
Sorry, I'm familiar with Link.
Right. Okay. And so this Maria Spink is her name. I don't know if that name rings a bell, but she told me that Mark Grotsky is a family friend, or that's kind of how, like, she has some information that indicates that that Mark Grotsky is a family friend of the Keiths. So, so I don't know where these two defendants currently live. So I contacted Mark Grotsky because I thought, because since I knew that he had known them previously, I thought he might accept service of the statement of claim on behalf of them. So I thought, I might as well just see if he would do that, since he knows them and since I don't know where they live. But so Mark Grotsky told me he wouldn't accept it, but he means that he was aware that I filed this lawsuit against the Keiths, and therefore he could inform them about it and warn them that I'd be trying to contact them. And based on my knowledge of these people, they're evasive and they're kind of jerks, to put it politely. So, so I have the Keiths phone numbers and I have the Facebook page of one of the Keiths. And in retrospect, I probably shouldn't have contacted Grotsky, but because now I kind of suspect that he's warned them that I'd be contacting them. But anyway, so I got an extension for service of this statement of claim for 3 months from April 20th, right before the limitation date was running out. So getting, I'm sorry if I'm meandering a bit here, but so not knowing how else to contact these two defendants, right? Because Grotsky wouldn't accept it, and and they don't live where they used to. I found out that I could get an order of substitutional service via Facebook, and since I know one of their Facebook accounts, and I have two email addresses for the other, so what I did was I wrote an affidavit for this reason as support for getting an order for substitutional service, and I filed this affidavit on Monday, June 6th in the morning. And so I was planning to go in front of a judge to get the order, but I didn't get to the courtroom on time, at 10 a.m. to go in front of a master to get the order. So that very night, on June 6th, the Facebook account of the defendant that I was going to serve it to was changed to a different account. And the thing is that I didn't actually notice that change had been made because the username of this Facebook account only changed slightly. And the Facebook account I knew redirects to this new Facebook account. So, and it's just a username, it's not a real name of the person. So I went to court on Tuesday, on June 7th, the day after I filed the affidavit, and I got the order for substitutional service. But in the order, I specifically named the old Facebook account. And then when I served this with a Facebook messenger, I sent a message to the user with the statement and the substitutional service order as attachments, and there was no problem, so it was sent, but there was no response to it. And so the thing is that then I found out that the Facebook user account had changed, and that's why I believe Mark Grotsky had somehow found out that I filed that affidavit and then that night warned them and then changed the Facebook account. And I know that that may sound paranoid, but I can't imagine why else that would have happened.
Gotcha.
So and that's the reason why I was asking you whether a lawyer would have technically the ability to search for a statement based on a username, or based on a defendant's name. And I guess you don't know whether that's possible or not.
Unfortunately, I do not.
Okay.
I suspect it is, but I can't be certain.
Right. And I guess that was kind of the thing, is I was wondering whether if there was any way to find out whether a lawyer had tried to access a statement of claim in that way, like by searching for it, like if there's a log of activity where a person logs into an account to be able to search a database and pulled up this record of this statement. But I guess you're thinking that you don't know, probably, I guess.
Unfortunately not.
Okay.
I have no idea.
Huh. Yeah, and I apologize if this is a very technical sort of thing, but like I'm just trying to figure out how I filed this affidavit for service, and suddenly this person's username changed, and I know that I had contacted this lawyer, Mark Grotsky, and so I'm trying to put this together. So I guess the thing about that is, I suppose I can't make a complaint against Mark Grotsky for that because there's no way to prove that. Is that probably true?
That's basically what it boiled down to. You're still entitled to file the complaint on your suspicion, but without anything to back it up, we wouldn't be able to do anything.
Right. So, like, you could, in theory, you could contact him and ask him, but all he has to do is say that he doesn't know anything about it.
Yeah,
like,
and if it's he said, she said, and there's no way to prove it either way, we can't really take any action.
Right. Okay, well then I guess that's kind of the first part of that. So the second thing about Grotsky is that he swore a false affidavit in May 2013 related to this in previous involvement with the Keefe defendants, and he knowingly witnessed the swearing of a false affidavit by one of the two defendants. And I understand that that's a criminal offense, but I don't think the police are going to do anything if I submitted a report on that. And so I guess what I'm saying is, like, can I make a complaint about that?
Yeah, absolutely.
Okay.
Any false statements to court, we want to know about it.
Right.
Now, again, there is the matter of being able to provide evidence to support the allegation.
Right. And basically all of my evidence is documented. Like, I know it's kind of it's a bit of a strange thing for me to be able to say that he swore a false affidavit and witnessed the swearing of a false affidavit, but like I've got the documents that he swore, and I can prove that they were done like with deceit, I guess, and that basically he knew that he was lying when he swore this affidavit.
Yeah,
So
that would be enough for us to at least start an investigation.
Okay. And like I say, because that's a criminal offense, would it be something that you could, would you as the Law Society pursue a criminal investigation against the Grotsky and the other defendant for that, or would it still be up to me to do that?
It would probably be on you because you're the one who has the evidence. Once evidence is submitted to us, it's very rare for us to go outside of this. We usually only contact the Solicitor General if we believe that there's an imminent risk of further damage being done, like money being stolen or a person's going to get hurt or something like that. But we can't tell the person who's filing a complaint not to file with the court or not to file with the police. So I usually recommend, if you want to make sure that the police are aware of this, you should do it yourself. Right.
So, and I guess obviously that means that it's not mutually exclusive. Like, I can file this complaint with you about him swearing a false affidavit and also go to the police with that.
Absolutely, yes.
Okay, and obviously there's no statute of limitations for that. And the reason why I also want to file a complaint about this is like I don't believe the police will do anything about this because they're a defendant in my lawsuit, and this swearing of the affidavit is like a smaller part of a bigger criminal story, I guess. But anyway, so I can file a complaint about Mark Grotsky's for that, so that's good to know. Let's see. Okay. Right, and like I say, the false affidavit aspect is provable, and I can in fact prove it. So so I guess the on that note, like since this is a pretty complicated situation that involves documents, I would want to be able to email this to you. And so like I noticed on your website, you just have like a contact form. Do you have like an email address as well?
I can give you my direct email. You can send it in straight to me.
Okay.
It's my name, Trevor.Jones.
Okay.
At lawsociety.
Okay.
.ab.ca.
Right. Okay. And so that's good. Okay, so I'll do that. Okay, so the next couple of lawyers are Joseph Ferraco of Weir Bowen and Jeremy Taylor of Field LLP. So so I filed my lawsuit against EPS and the other two defendants and a few other defendants as well on April 22nd of 2015, and I had a complaint against EPS like through their professional standards branch, which was like I don't know how familiar you are with police and that sort of thing.
I have a passing familiarity.
Okay, so so my complaint against EPS was concluded with a disposition letter from the chief on December 1st of 2015, so just last December.
Okay.
So I appealed that complaint in January of this year to the Law Enforcement Review Board. I'm sure you're familiar with them.
I've heard of them, yeah.
Okay. So Ferraco represents 3 EPS members in my LERB, that's the Law Enforcement Review Board appeal, and Karen Agnehatri of EPS was representing the chief in my appeal as of the morning of April 15th, and then I served my lawsuit on the chief in the afternoon of April 15th. And then I learned Jeremy Taylor, was representing the chief in my LERB appeal as of April 29th. So I don't know whether that change was made because I filed my lawsuit, but I think it was. But I guess I don't know, and I don't know if it matters.
Particularly, I mean, as a client, he's allowed to switch lawyers whenever he wants. So.
Right. So then I served the other EPS defendants, and then I received statements of defense that were filed on May 4th, May 6th, and May 10th. So the May 4th one was specifically related to the chief, and then the May 6th and May 10th ones were from the other EPS members. So Taylor is representing the chief in both undertakings, right? My LERB appeal and my lawsuit, and Ferraco is representing the other EPS members in both undertakings. So my question is that a conflict in any sense, like for them to work on both undertakings?
The nature of a conflict would be if he's basically wearing 2 hats, and the 2 hats are at odds. If he's working on the same side, essentially, it's much harder to call it a conflict. But if he's working, if on the one hand he's working against himself, then that would be a conflict. Ultimately, though, we don't have the authority to declare something a conflict. That power rests exclusively with the judges.
Okay, I see.
So if you believe that there is a conflict, your best bet is to bring a motion to the judge explaining why you feel it is and asking him to pass, to examine the motion and make a declaration.
Okay, so that's something like, because I thought that you'd have to bring up a possible conflict like early in the process as opposed to in front of a judge.
Every lawyer is expected to run their own conflict check, but sometimes they don't get caught, in which case if the opposing party becomes aware of it, they can bring it up whenever they want.
Right. They can bring it up whenever they want. Like, but if I bring it up,
generally speaking, it would be as soon as you learn of it, or as soon as you begin to believe that it is a conflict,
right,
or as soon as you have some sort of confirmation.
right, and I guess, you know, like, I mean, I guess, like, I don't, like, I mean, obviously a conflict, it's a bit, it's not a typical conflict because it's a conflict where, like, I think, like, from my opinion, from my perspective, it's problematic to me that these two lawyers are working on both my appeal to the Law Enforcement Review Board and my lawsuit. Like, in other words, I feel like they could use information that's given to them that they see from LERB and use that to form defenses for the lawsuit. Like, that's the sort of conflict I feel is a problem.
Yeah, and it's entirely possible. I mean, that's kind of the nature of the second. There's a couple of different ways of defining conflict of interest, but that's one of them. They cannot use information from one proceeding in another.
Right. Right.
So if that is a possibility, then you should make the judge aware of it and have him, examine the possibility of that. Because if he agrees with you, then he's going to have to ask the lawyers to step down.
Right. And on sort of a similar question, like, are they, like, Farraco and Taylor, like, they're from two separate law firms, but one of them is representing the chief specifically, and the other one is representing the other EPS members. And are they allowed to work together on both undertakings, like, despite being at two separate firms?
Well,
because they're obviously working together. Like, I know that for a fact.
Because they're on the same side of the lawsuit, there's a certain amount of collaboration that's going to be expected. If they're working at the same firm, I mean, honestly, if everybody went to the same firm and got one lawyer to act for them, then that would be almost the same thing. The two lawyers acting for the defendants are expected to collaborate or at least coordinate.
Okay, they're kind of expected to, like, since it's within the EPS umbrella.
Yeah. Well, to a degree, it's more that they have been put on the same side of the lawsuit.
Right.
I'm assuming that the allegations against each are related.
Right. Well, the thing, I mean, when I had my, like, I got Tom Engel to write my statement of claim. So he read my documentation and then wrote up the statement of claim, and, like, I guess it's basically like the nature of a case against EPS that the chief is named as a separate defendant, even though he doesn't really have anything to do with the actions of the members. So, like, in my particular situation, I'm actually, because this involves to some degree my complaint, which was signed by the chief, I actually make particular allegations against the chief based on what he's written in his dispositional letter. So he is actually more involved than, like, when you see on the news that the police are being sued, the chief really has nothing to do with what the members do. He's just he's a defendant, but he's not directly involved with those members' activities, right? And so, right, exactly. That's exactly how I would describe him as well. Like, so that's why I presume Tom Engel wrote the statement of claim so that Rod Connect is a defendant as well as the other EPS members, because he's liable for the other EPS members even though he's not directly involved.
Yeah.
So, right. So, and so that's the thing, is that Taylor is representing the chief and then Farraco is representing the others. But I guess since they're all EPS, there's no reason why they shouldn't, like, they're allowed to work together, I guess, basically.
Yeah, my read on it would be that it's almost expected that they would be working together. Right.
Okay. Okay. So now, so we were talking about that they're involved in both the undertaking of the LERB appeal and my lawsuit. So as part of the LERB appeal, a record was produced which contained all the information that was part of the response to my complaint to the police. And so I was told that I couldn't use material from the record as part of my lawsuit. And like you were saying, that's your understanding as well, is that because it's a different undertaking, it can't be used in a separate undertaking, right?
Yeah, basically there can be no cross-contamination.
Right.
If something comes to light in one proceeding, it still can't be used in the other proceeding unless it eventually becomes part of the public record.
Right.
So when the two are going on at the same time, that's virtually impossible.
Right, exactly. So, and that makes perfect sense. So, but the thing in this that I'm raising an issue about is that, like, I've received the statements of defense from Taylor and Farraco, and those statements of defense use material which I believe they could have only obtained from the record that LERB has, right? And LERB has told me that they haven't asked for permission to use this, and I don't know 100% if they got it exclusively from the record. So, so I guess, could I make a complaint about that to the Law Society, or do I make it, like, a complaint about that? I mean, I'm kind of talking to LERB about it as well.
Yeah, you can make the complaint. Anytime, the long and the short of it is, anytime that you believe or perceive that there has been an ethical violation, then you should be reporting it to us. It's the only way that we're allowed to get involved or to look into it at all.
Right. So I guess even, like, I mean, obviously, so in a situation like that, would I give you the statements of defense and then the material that I think that they're using improperly? Yes.
The more information you can give us up front, the easier it's all going to be to sort out. But yeah, if you can give us an actual copy of the materials, then that's a heck of a lot easier than just about anything else.
Right, exactly.
You go through the rigmarole trying to get it from them.
And so would I have to ask LERB permission to give that information to you, or is that kind of like okay to do?
If I were you, I'd be on the safe side. I would ask. That being said, our process here, all complaints, are kept confidential unless it proceeds to a hearing and the lawyer is found guilty.
Okay. So I guess...
it becomes public.
Right. So probably, I guess, like, thinking about this now, I think it probably would make sense to me to tell LERB that I'm going to ask the Law Society to look into this possible unauthorized use of this information. Does that make sense to you? To, like, inform them, ask for permission, and just so that they know 100% that this is what I'm doing.
Yeah, and then definitely explain why. And then it shouldn't be an issue.
Right. Okay.
But if they come back to you and say, we can't authorize that, then I would not be comfortable taking that information, because if it does proceed to hearing and become public, then information that they want to remain confidential is being publicized by us.
Right.
And that's not a line that we're comfortable crossing.
Right. Okay, so I guess what I should do is ask LERB for permission to use this information, right? Because, I mean, I'm going to ask them for permission to use it for my lawsuit as well, but then mention to them that I'm going to forward this information to the Law Society so that you can actually investigate whether they've improperly used the information.
Yeah.
I guess that makes sense. Okay. And let's just see. So, right. And I guess, and I mean, like I say, I've got all the documents that I believe that they use, because I'll just give you a little bit of background on that. Like, they're Alberta Health Care or Alberta Health Services documents that I gave to the police as part of my complaint. And so, but so in other words, they're part of the complaint, but the only way these lawyers would have access to it would be through that record. So, so that's kind of the reason why, because in other words, I don't think that Taylor and Farraco could have contacted AHS between the time that I served the statement of claim and the time that they filed their defense. So in other words, that's the only thing that I can think of, is that they got their defense information from my records that I provided that were part of the record. So I guess, sorry?
Yeah, I'm just agreeing with you.
Right. Okay. So I can just provide all that documentation to you, and I'll just first ask permission just to make sure that everything's on board, and then just send it to your same email address. Okay. And so I guess the thing about that is, so if I make a complaint about that, would there be actual repercussions for them using the material without authorization, or could they just retroactively ask for permission?
Generally speaking, once they've done it, that's the act of doing that sort of thing without permission is the violation. So whether or not they get permission afterwards, it would still count against them. It's still the sort of thing they have to answer for.
Right. And that's good to know, because I worry that they could just I guess the reason why I ask about that is could I actually have their statements of defense that are based on that information removed from the statements of defense, or is that kind of set in stone anyway? And
that I can't give procedural advice or legal advice, so I couldn't answer that question.
Right. Well, I guess that's not a repercussion that could happen. Like the statement of defense would have to be rewritten without that information. That's nothing that.
That's something I honestly can't answer. I genuinely do not know.
Right.
You would have to ask. Well, you'd have to ask a lawyer.
Right. Okay. So I guess you are not a lawyer.
I am not.
Right. Okay. And I guess so you're saying that there would be repercussions against them for using that material, but if they use that material without authorization, could the fact that they use the material without authorization work in my favor for the lawsuit? Basically points for me because they use this information, quote unquote, illegally?
Potentially. Ultimately, I think that would be up to the judge or the JP, whoever's overseeing the whole thing. But it is potential because it speaks to them kind of abusing the process and the system.
Right. Okay, well that's good to know. And so, okay, so that's two things. Do you have time for me to discuss one more thing?
Sure.
Okay. So like I was saying, I sat down with Tom Engel to file this statement of defense, and so when he wrote the statement of defense, we had a meeting before it was written, and it was just like an hour consultation, and I gave him a bunch of documents beforehand. So then he filed the statement of claim, and then so he said that he wouldn't be able to act for me just because he's too busy, and I think he was telling me that he's moving towards more criminal defense instead of civil litigation. So he told me that he would not be able to act for me, and nobody in his office would act for me, and that was a problem because nobody else in Edmonton, as far as I can tell, will work on a case that involves the police. I find that really hard to believe, but apparently he's the only lawyer in the city who does cases that involve the police. And so I called pretty much I'm sure every law firm trying to find somebody who would help me with this case, and nobody would because it's a conflict because they won't do a case against the police.
Gotcha.
Right. So Tom said, I can't work for you, but I can give you the names of lawyers who can help you with this, right? So, and that's actually part of his letter of engagement, which he gave to me before I paid the retainer. So it's in writing that he said he would help me find a lawyer. So, and I can obviously send you that letter. So the thing about that is that so then we had, he filed a statement of claim, and I was very, to be totally honest, he didn't do a good job. He actually made factual errors that were different than the documentation that I provided. It was I was very disappointed with the actual statement of claim, and I don't know whether that's something I can complain about or not, because, like, is that something that I can raise as a complaint, or is that kind of too subjective?
That becomes a bit of an issue. If he is actually making blatant mistakes, then that's something that we need to know about, because if he's making mistakes on one document, how many others is he making them on? And how many are not getting caught? It's the sort of thing where we need to go in, take a look, and make sure that he is actually doing the job properly. Right.
Well, I'm glad you're mentioning that, because, I mean, like, I was really kind of upset when I read the statement of claim, which he filed without, like, he didn't send me a draft for me to review. He just went ahead and filed it and then sent me a scan, and it's like, I was looking at this and I was thinking, well, that's not true, and I gave you this information in writing, so why are these factual errors there? So I managed to, and I even told him, like, you can fix these things before and refile it, and he said, no, well, you can make those adjustments before you serve it. So I thought, okay, I guess that's not too bad, because I can just make those adjustments myself and then file an amendment. But like, I arranged to discuss these errors with him at a meeting, so I had to pay another $400 an hour to talk to him about these mistakes that he made. And so we went through the mistakes, and I told him, this is what it should be and all this. And so then at that meeting, he gave me the name of a lawyer who he said I could work with on this. And I mean, obviously there's no guarantees when he gives you the name of a lawyer, but I assumed from what we were talking about that this lawyer wouldn't have a conflict with the police, which is the main issue that I was having, trying to get a lawyer to work with me. So he gave me a single name of a lawyer, and so I had a couple of meetings with this lawyer. It's Greg Lintz at Terabane and Company, and I gave him, because I wanted to, I wanted a lawyer to work with me, and I wanted a lawyer to help me file the amended statement of claim to make sure that everything was proper and accurate, and I wanted to add some new information and a couple of other defendants. So I wanted him to understand the case and everything. So we went through these documents in a couple of meetings, and Greg Lintz didn't charge me for anything. There were just like 2 free consultations, I guess, and then suddenly Greg Lintz stopped returning my calls, and I left a bunch of messages with him. And I sent him a couple of emails asking for responses, and he just didn't respond back. And then I finally emailed his partners at his firm, and then suddenly Greg Lintz responded back, I'm not going to work with you on this case. And it's kind of like, although I didn't pay him, which is a good thing, I wasted a lot of time and energy producing information for him and all this, and I thought that, I was under the understanding, and I was completely willing to pay him to work with me on this case. So then I did some Googling, and I found out that Greg Lintz is a friend of Tom Engel's, and I basically kind of put 2 and 2 together, and I thought, okay, so Tom Engel just gave me the name of a friend of his to work with on this case, that he wasn't somebody who was, I actually phoned Greg Lintz's partner, and I asked her, would you recommend Greg Lintz for this case? And she said that she wouldn't. She said that she would recommend Tom Engel, which, of course, that doesn't help me, because Tom Engel said, contact Greg Lintz. So this is kind of, especially, and so then after that, I contacted Tom Engel, and I said, okay, so I had a couple of meetings with Greg Lintz, and he's not working with me, and, and I explained all of the emails and communications that I had with Greg Lintz, and then Tom Engel replied, I'm not willing to act further with you on this, and that's it. So it's very upsetting to me that I have nobody to work with, and Tom Engel told me in writing before the engagement letter, or before the retainer was paid, I'm going to help you find a lawyer, and then he just gives me a single name of his buddy, and basically his buddy just led me on for 3 months. So I guess, so my question to you, so I was, wondering, is that something I can make a complaint about?
Most certainly, yes.
Okay. So, and like I say, this is a lot of information for me to tell you all at once, and I appreciate that,
That's no problem.
Okay. So, and that's also why I was wondering if there was a limitation date, because I'm still involved with LERB and I'm still trying to reach those couple of defendants. I'm not going to give this to you today or tomorrow. I just wanted to make sure that there's no time restriction, that I'm not under any sort of pressure to do this. I don't know when exactly I'll be getting back to you about this or sending you this information, but it's not going to be, it won't be, I don't know exactly when it's going to be. I just wanted to kind of run this by you. So I guess that's okay?
Yeah, absolutely.
Okay. And obviously, like I say, I wanted to just make sure that these are things that I can actually bring up as complaints, and I understand from what I'm hearing from you that these are legitimate complaints.
At the very least, they bear looking into.
Right.
Yeah. I don't make the decision as to what sort of disciplinary action is taken or what the exact threshold for evidence required is, but I can tell you that is the sort of thing that we need to look into.
Right, right. Okay, so I think that's everything for now. So I guess if I have any further questions, could I just email you the questions, or do I need to call you or anything?
Yeah, you've got my email address. You can just send it straight in, and then I can give you a complete response.
Okay, and I guess another thing I was kind of wondering is, once I give you this information, and I guess to be totally honest, it might be quite a bit of information. I was kind of wondering what your backlog with other cases is, in terms of the time frame for even looking into this. Would it be months or?
Generally speaking, I can't make a super accurate promise, especially during the summer. We do have a backlog, as you say. It will likely be a couple of weeks before you would hear back from us, but our goal is to get these done and wrapped up within a couple of months.
Right, right, and
if you were to get it in soon, it would probably be before Labor Day.
Right. Okay, and yeah, and I guess that's it's tricky when when these lawyers are. Tom Engel, of the 4 lawyers that have named to you, Tom Engel's the only one that I've actually paid for services, so it's a bit different than the other ones where, but, yeah, I guess that's just it's, and especially since it's with Taylor and Faraco, that's in, dealing with an ongoing lawsuit. So yeah, I guess I'll have to think about exactly how to do this. In other words, I guess I guess at the very least I should probably send a separate email for each lawyer, just so that it's not everything at once, right? That would make sense.
That would probably be better. And when we do proceed with these, we do ask that we keep them as separate as possible.
Right.
Yeah, keeping them separate up front is probably the easiest way.
Right, right. Okay, so that's what I'll do. So I think that's everything. So yeah, like I say, if I have any questions, I'll send them off. And I think that's everything for today. So do you have any questions for me about any of this?
No, I'm here for you.
Okay. And so I guess that's everything. So I guess have a good weekend, and thank you for your time.
Certainly. I hope you do too.
Okay, thanks. Bye.